Hello guys, welcome to my next Monday Bagel episode. My today guest is Sari Depreeuw. She's partner of Crowell and Moring, and she's also professor of IP law at Catholic University Louvain-Saint-Louis in Brussels. Sari, it's great you could join me.
Thank you so much for having me.
We will chat about IP law and AI. So I would like to ask you at the beginning if you can elaborate on how EU regulations like DSM directive are shaping artists' awareness and legal options regarding the use of AI for their creations.
It's a very interesting question, but it's a very broad question. I think one of the points that is interesting to note is that the DSM directive, so the Copyright in the Digital Single Market Directive, was adopted in 2019, and the European legislator had some awareness of AI, but we had no idea of the huge impact of technologies such as ChatGPT. So ChatGPT, they've celebrated their first year like a week ago, and it's only now that we really understand the strength and the impact that this technology may have. And we've seen a lot of court proceedings in the past year, so artists really start to worry about substitution effects, because the images, the photographs, the text, even the music are so real that they might actually be replaced at some point. Perhaps more mainstream types of creations might actually be replaced by AI. The artists become very worried that their creations might be used to train AI, and in order to get some output that is actually of such a high quality that they might be replaced. It's important to keep in mind that this evolution was not really what the European legislators had in mind when they adopted the DSM directive. And so the purpose here was to encourage the investment in technology, including AI technologies in Europe, because we're always afraid of lagging behind the US and China. But now we have some exceptions to the copyright protection that facilitates the creation of these powerful AI technologies. And we're not really sure, I think, whether the balance is right. So at the European level, since the InfoSoc directive in 2001, we have economic rights that have been harmonized. So we have a reproduction right, we have a right of communication to the public that's harmonized throughout Europe. So in all the European member states, authors have more or less the same protection. As far as the exceptions are concerned, there were more differences between the member states. So in 2019, with the DSM directive, the legislator has tried to make this a little more coherent and has introduced some new exceptions to facilitate certain digital uses. And so, for example, new exceptions were introduced called the TDM exceptions, or the text and data mining exceptions. So these exceptions should allow, for example, universities in the context of scientific research to go through these huge bodies of scientific literature to find links between certain symptoms and certain foods or pollution, and to make perhaps see patterns where, for example, it would take much, much longer to see these patterns. But then they extended this possibility to use these text and data mining technologies to other types of users, even if the purpose is not just science and non-commercial use. As long as the text and data mining user has lawful access to the works that they want to use, or the information that they want to use for text and data mining, they can do it for any type of purposes, so including commercial purposes, unless the authors or the other rights holders have reserved the use. So if there's an opt-out, as we call them, then they have to stop and they mustn't use the works for text and data mining purposes. Then they have to go and negotiate an authorization, perhaps pay a fee. And if they can't get an arrangement, if there's no authorization, then they can't use the works for text and data. So that's a very interesting point.
Do you think it's balanced? You mentioned there may be a lack of balance.
I think it's difficult to use this opt-out right in an effective way, because it's a very theoretical construction, in the sense that, as a matter of principle, under copyright law, if you make a reproduction, you make a copy, even a technical copy of a work, you need to ask the prior authorization of the author. If you don't have the authorization, you may not reproduce the work. So that's very simple. Unless you have an exception, and then no authorization is required. The balance is shifted. The burden of the authorization is shifted. So there's a reproduction, but you fall within the exception for text and data mining for commercial purposes, let's say. The user does not need the authorization of the author unless they've opted out. But in practice, there's no technical standard, there's no register, or there's no centralized database where we have an overview of all the creations that are protected under copyright, in which you can do this opt-out, and in which the users can go check if there has been an opt-out, yes or no. So what is often referred to is the robot text type of opt-outs, but that's on websites, for example. So you can give instructions to crawlers for search engines, for example, and you can give an instruction: I do not want my website to be crawled. I don't want certain parts. I don't want to be indexed. I don't want them to appear in search engine services. But I'm not sure whether this is the right level, because in a web page, typically, you will have many, many works from many, many authors. So there will be videos, text, pictures, many types of works. And those authors will not be the administrators of the website. So the authorization will be dealt with by the admin of a website, who has not necessarily checked with all the authors whether or not the website should be crawled and should be available for search engines or for AI crawlers alike. So there's a difficulty because, again, it's at the level of the web page. But if one picture appears on one web page, but then it's used on another web page as well, all of these things are legitimate. And an opt-out has been made on one web page, but has not been made on another web page, what is the user to do then? We still have a very, very practical issue with these opt-outs.
There is a big discussion on training data, especially in the US. And we know about the disputes that are pending before US courts. My question is, would they be possible in Europe?
Well, I think there's two sides to this, and we see this in US cases that are pending as well. There's always the question of the input. So what we just discussed, the training data that may be protected by copyright, but there might also be neighboring rights for artists. There might be producers' rights. There might be publishers' rights. There might be database rights. So all these rights are stacked as well. So it's not even sufficient to have the authorization of the authors. You need to check whether all the protected matter is actually cleared. The text and data mining exception will cover all these rights. So that's on the input side. And then on the output side, the question is whether there's an infringement on existing work. So, for example, Sarah Silverman, one of the authors who's initiated legal proceedings in the US because she found big chunks of her novel, I think, to be reproduced. So summaries of her works that were reproduced allegedly. So we'll see what the judge says in the output of some AI services. And there the court will have to apply the typical infringement tests. One of the big problems that we have, or that authors may have in this type of litigation, is that the output in many cases will not be exactly a reproduction of their work, but it will be more something in the style of. So, for example, there's many applications where you can upload a selfie, for example, and you can ask to make an adaptation of your selfie in the style of Andy Warhol, for example. So the very typical, very easily identifiable artist, those styles. Now, this type of adaptation is not protected because a style as such is not protected under copyright. But that becomes a problem if you get these non-literal uses, these copying of style without copying the actual original elements of the work itself. So an author, especially graphic authors or designers of logos, of types of music, like minimalist music, for example, it will be very, very difficult to protect their sources of income because what is being created is not an actual copy of their work. It's not a protected adaptation, but it's just copying a reproduction of their style, which is not protected under copyright.
My last question is, how about protection of outputs? If they are protected, what's the approach in Belgium? I discussed this with a few other IP specialists from different countries, and there is a bit different approach in Italy, for instance, or in Ukraine. If it's AI-generated output or output generated with the help of AI tool, is it protected? And what's the approach in Belgium?
It's a very good distinction that you make immediately between the output that is autonomously generated by AI and output that is made with the help of AI. So if there is output that is generated mostly by AI or entirely by AI, there will be no protection. And originally this criterion was a national criterion, but since the InfoPact decision of the European Court of Justice, actually the originality criterion has been harmonized at the European level. So all European jurisdictions will take a look at whether or not there's a margin for creativity and whether or not a human author, it's not explicitly said so, but implicitly it's a human author that uses this margin for creativity to make choices that lead to an output that reflects the personality of the author. Implicitly, that means that the author of work protected under copyright needs to be a human. So a output that is autonomously generated by an AI system will not be protected under copyright. By contrast, there's many artists that are already working with AI systems, but then have much more complex and a much more creative approach to AI. And so this is very interesting because it forces us copyright lawyers to reconsider as well, what is it that we want to protect under copyright? Because up till now, it was not really clear what it is that we are looking for. So do we look for the human input somewhere in the process, or do we really need to see the human intervention at the level of the outcome, the painting that we're seeing, or the photograph, or the music? Do we really need to see that the human intervention has been at that level? Up until now, in a more analog type of creative process, the two coincide, because when I'm painting with a paintbrush, it's very clear that the process is a human process and the outcome is directly related to my human process. And so I can work on the painting immediately and my input as an author will be directly visible in the output. But as we are making more digital process, you can have a lot of choices in the process. So for example, which data set am I going to use? Which algorithms am I going to use? Which selection am I going to make? Which additional prompts am I going to ask to come to a particular result? But there will always be some part that as a user you cannot control, and you can probably explain all the choices that the system has made and the decision, how have I come to this particular outcome? But as a user, you cannot directly influence the outcome. So there's collaboration between the human in the form of prompts and then an AI system, but the distance between the human and the outcome will be much larger than in analog means. So there we will actually have to wait until the courts take a position.
Okay, a great explanation of EU regulations. Thank you, Sari, for this episode and this discussion, and thank you for being with me.
Thank you so much. It was my pleasure.